Okay, this is my November the 2nd, 2017 probation revocation hearing that ended up being continued. So it's broken up into three parts, and since I don't know how to upload an MP3 audio recording to my blog, I'm digitally recording with my camera. And Annabelle, she was just something that I found on my computer, that came with my computer, that I'm choosing to use as the video backdrop for all this. And I have no control over what animation comes up on the screen, but I thought to go with Annabelle's sheep. Black sheep of the family, pink sheep of the family, I don't know, kind of funny.
Well, so if this is recorded, because it says it's recorded, this is the magistrate court, DeKalb County. This will be the hearing.
That is our Honorable Judge Matthew McCord.
State versus, or the county, DeKalb County versus James Avery. The only thing I know to do is to turn on.
Can we try playing it back to see if it works?
I do not know.
So we find out if someone that's like that. And again, we recently had a situation in the courtyard where it said it was recording and then it's something that was recording. Yeah.
Well, let me ask, because this is outside of the purview of my skill set.
We're waiting for
Okay. I would hope so. I would hope so.
It is recorded.
Sure. Okay.
You also get the IT department.
Okay. Thank you very much. I'm doing great. I hope you are.
I'm gonna go to
Alright, this will be the DeKalb County Magistrate Court Ordinance Division. This is a 9 o'clock specially set case. DeKalb County versus James Avery. Is the county ready to proceed?
County is ready, Your Honor.
Is the defense ready to proceed?
I'm sorry, Your Honor, I was speaking with probation.
I'm just asking, I asked the county if they're ready to proceed, and I'm asking if you're ready to proceed.
Your Honor, we've asked the court to inquire into the reporting mechanism, whether that is working. That would be our first concern. We also are expecting the devices in order to help Mr. Avery hear. When it's spoken about those, I know you can't hear. That's why I'm asking.
So we have them right here. I was trying to get a status about whether we're ready to proceed, and that
Is part of it.
part of it.
If we may have the opportunity to test this, and if we can find out what the status is of the court.
These people are here to do that right now.
Okay. So barring checking that these, we would also plan to invoke the rule of sequestration if the state is planning on having people testify.
Understand?
Can we get the case reporter to power?
My client is asking for a case reporter. It was my understanding that it was recorded audio. There's an audio recording. He is asking for a court reporter. I had said that he could procure one.
So would you instruct your client not to speak? Okay? Because he knows the rules, and you're speaking for him. You're representing him. And he needs to speak to you. And we're not going to have that. We're not. So he needs to control himself.
Yes. Let's try.
Come Sean Friday.
Sir, stop your outburst, okay?
Can you, Judge, can we Can you hear me when I'm standing here?
Yes.
Okay. So we're just going to make sure that we speak into the mic. Okay?
It would be nice to have a tape recorder. So we don't need all that as a fact.
Is McGoy.
I could have had somebody your film.
Sir, we are talking.
If he wanted to bring a court reporter, he could have brought a court reporter.
It was provided for me last time, I just paid for it.
I'm sorry, Your Honor.
There is a recording. This courtroom is set up to record.
I understand that, Your Honor.
And the recording, my indication is the recording is on. I've asked the staff to check. They've checked, and they say every indication is it's recording.
Okay.
So that is a recording of the proceeding. I'm not going to tell him again to not speak when it's not his turn. All right? We're not going to have that.
I understand that, Your Honor, and you also know that there are some mental health issues that we have raised repeatedly. All right?
And I've-
the ability
and
to
I've-
assist counsel has been one. You know, we had attempted to get Georgia Regional to do this. They will not because it is not listed as a crime. According to the statute, that is defined as a misdemeanor or a felony, not as a city ordinance. We have asked the courts for monies to perform an evaluation, and were denied that the last time that we were in here.
That's because early on, I asked if you all wanted a mental health evaluation, and you said no. And it was only after the trial and the conviction that you then asked for a mental health evaluation.
No, Your Honor, I brought that up at the beginning of the trial, and if the court cares to review the transcript,
So that's correct.
it is there.
That's correct. It was at the beginning of the trial, after I had offered and asked whether you wanted a mental health evaluation, and I had been told you didn't. And so that issue was raised. It wasn't raised for the first time at the trial. It was raised well before that when I asked if you wanted a mental health evaluation, and you said no.
And as the court also knows, competency is something that is fluid. There are times where someone may be deemed competent or may appear competent, and other times that they are not. At that time, the question had to do with his ability to assist.
Are you taking the position that he's not competent to assist you?
With the outbursts, I questioned his competency to go through proceedings.
So are you asking for the court to order a mental health evaluation?
I would prefer that, Your Honor. However, it would also mean the funds to procure one, because Georgia Regional has declined to do one. I have spoken to their attorney, Greg Bagley, in the past. He has provided me with the statutory authority. And in my research, I believe he is correct, unfortunately.
Judge, if I may ask a clarification question.
Yes, sir, Mr. King.
May I inquire, is defense counsel asking for a mental health evaluation or a competency evaluation? Because even though they both deal with mental health, they are more separate and distinct under the law. I just wanted to make sure I understood which one the defense counsel was asking for.
Your court's concerns are not mental health evaluations. The only thing that we can address in a criminal setting is competency.
So you're asking for an evaluation of the defendant to determine if he is competent to assist you.
And it comes under ability to assist. I do not question Mr. Avery's knowledge of the system.
Right. What is the name of the lawyer at Mental Health, Georgia Mental Health?
With Georgia Regional, it is Greg Bagley. Would the court like Mr. Bagley's contact information?
That would be great. Thank you.
If you would give me a moment, I can
Sure.
pull it up.
Leading up to the trial, I also paid for the mental health evaluation.
So we can stop recording right now and play it back just to make
Yeah, I can hear you.
Let's do that.
And Judge, if I may just add something to the record regarding the county's position. If defense counsel is concerned about Mr. Avery's competency, and if by extension the court is interested in having somebody assess Mr. Avery's competency, while the county cannot directly speak to Mr. Avery's competency, he is not the county's client, Judge. And in our opinion, he has demonstrated competence, but I understand what Ms. McGoy's argument is here today, Judge. We would ask for a civil commitment to Georgia Regional to determine that competency until and if a time when Mr. Avery is determined to be competent. Because, also in the county's opinion, he is a danger to himself and he is a danger to the members of the community, Judge. So I think that is an issue which we have raised through the petition, the Probation Revocation petition. It's also something I feel compelled to place on the record today. Since this issue of competency has been raised, I think there are other mental health issues which also tie into that.
Your Honor, at this point in time, regarding civil commitment to Georgia Regional, it's premature and this is the wrong mechanism. If people in the community are concerned about whether or not he is an imminent danger to himself, others, or cannot take care of himself, the way to proceed through that is through a lay affidavit. At this point in time, there's been no psychiatric opinion that he is a danger to himself, others, and he's not been evaluated. He does not meet the criteria. And the word here is imminent. The word is not just talking about it or something that may occur in the future. It's imminent.
All right, Ms. McGoy, if I'm able to persuade Mr. Bagley that Georgia Regional ought to perform this competency evaluation, how long will that take?
You would have to ask Mr. Bagley. Typically, when I am doing an evaluation, I actually put in time frames to try to speed it up, but our time frames are 60 days, and that is speeding it up for misdemeanor cases. It then takes approximately 6 weeks to get an evaluation back. Now, it is possible that those are expedited with court orders. And the reason we did that, Judge, is it was taking an extremely long period of time before that.
I understand that. All right, Mr. Kemp.
Yes, sir.
And I just want to make sure I understand the county's position. County's position is that you are seeking a civil commitment.
Judge, my concern is this. Let me rephrase that a bit. A civil commitment has broad ramifications under the law, Judge. And what we are seeking is that this court order that Mr. Avery be held in the custody of Georgia Regional Hospital until and if he is deemed competent to either stand, well, not trial, but stand hearing for the probation revocation charges, Judge, or assist his lawyer, or I should say assist his lawyer, Judge, because both are important.
Your assisting a lawyer is a prong of competency.
Yes, Judge. Ms. McGoy and I don't disagree on the prongs of competency. My biggest concern is this. If Mr. Avery is incompetent, what is to prevent him from continuing to engage in the bad behavior in the community that he has done so? What is going to prevent him from, in the county's opinion, potentially harming himself or harming others and continuing to contribute to the conditions in the community which have a negative impact on public safety? So, Judge, that is the county's position on why Mr. Avery should be held in the custody of Georgia Regional pending the outcome of any competency evaluation. Again, Judge, I said civil commitment earlier. That language is probably a bit of an overreach. I don't mean it in the way that we would normally think of a civil commitment through Superior Court. But this court, I think, has the ability to order competency evaluation for Mr. Avery, and as such, I think also has the ability to hold that Mr. Avery should be held in custody of Georgia Regional pending the outcome of that competency evaluation.
Your Honor, I would disagree with that. As far as the requirements for someone to be inpatient come with a violent crime, there's no requirement there for that. Again, there has been no imminent showing of danger to self or others, no inability to take care of himself. He is here dressed, he is clean, his hygiene is good. He can obviously feed himself, he can clothe himself. That's where it comes with ability to take care of yourself. And if the court cares to look at the code section, I believe it's 37.3-1.
And a cat.
Tell me that one again, I'm sorry.
37.3-1. I believe that's a code section for commitment.
Okay. It's been a while since I had to look at it. Thank you. All right. Here's what we're gonna do. We're gonna stop the recording because we're gonna play it back to make sure that we are in
Thank you,
fact
Judge.
recording.
I appreciate that.
Okay? And while that's happening, I'm gonna step out and call Mr. Bagley. All right?
Thank you.
From a technical standpoint, we're in recess.
Thank you, Judge.
Thank you. All right. Whatever y'all need to do. Thank you. I really appreciate it.